Hello again, Francis Akinnuoye from Francis Law. One of the questions that lawyers encounter on a regular basis is which ground of divorce to proceed under in order to obtain a divorce. Many still wrongfully believe that they must show that their spouse has committed adultery. They may show that, but that particular ground is complicated and requires proof that adultery was actually committed. This would normally require a trial of the issue. In 1976, the Law Reform Commission of Canada, in its report on family law, recommended that to reduce hostility in the traditional adversarial approach to divorce, that the only ground to show a divorce should be breakdown of marriage. So, in 1985, the Divorce Act of Canada was significantly amended, and Canadian courts adopted a no-fault system. Under this no-fault system, spouses no longer had to proceed only with adultery or cruelty. Instead, they could proceed on the single ground that there has been a breakdown of marriage. Marriage breakdown is evidenced simply by the spouses living separate and apart for at least 1 year. So practically, what does that mean? So practically, that means that even if you separated yesterday, you can still file for a divorce today, because by the time a judge signs off on your divorce judgment, at least 1 year of living separate and apart from your spouse will have already gone by. So, although this no-fault system marked a major shift in Canada in making divorce less adversarial and more accessible, we still have a long way to go. For example, the automatic payment of the table amount of child support by the non-custodial parent, in some cases, serves as a financial windfall for the custodial parent, especially in cases where the custodial parent has managed to experience a greater economic advantage arising out of the breakdown of the parties' marriage, whilst the non-custodial parent experiences the greater economic hardship arising out of the breakdown of the parties' marriage. Therefore, family law reform should also consider that the amount of child support payable be based on a household comparison standard of living test. The same test used when applying for a claim for undue hardship. If an applicant for undue hardship is able to show that comparatively, payment of the table amount for child support under the standard of living test would result in a financial windfall for the custodial parent. In those circumstances, the court should be given the discretion to depart from the child support table amount and order an amount of child support that ameliorates the financial inequality of the two separate households. This family law reform suggestion would reflect the financial reality of many men and women who do not have custody of their children post-separation. So, be advised, the foregoing discussion should not be construed as legal advice and was not intended to be legal advice, but general information only. Should you require specific legal advice for your particular set of circumstances, feel free to contact our offices here at Francis Law and we'll be happy to meet with you. So until next time, have a blessed day.